May I proceed, Madam Registrar?
Yes, please.
Thank you. Good morning, everyone. This consolidated costs hearing is in the matter of CFI 24-2020 and CA 11-2020 held before Registrar Ayesha BinKalban. The sunset parties are represented by Al Tamimi and Company. Lead counsel is Mr. Carl Anderson. Hana Habib Al Herz is represented by Abdul Hakim bin Herz Advocates. Lead counsel is Mr. Abdul Hakim bin Herz. Thank you.
Okay. As this is a consolidated assessment, do the parties have an agreement as to who would like to go first?
Registrar, we haven't discussed that yet. It may, subject to your views, whatever you find most useful, it may be most sensible to start with the sunset parties proceedings simply because they're the larger ones and it might take more time to go through those. But as I say, subject to your views as to what would be most helpful from your perspective.
That is fine. I can see that Mr. bin Herz has something he would like to say. Yes, go ahead, please.
Please, if you may allow me. We just want to bring the court attention to part 38.14, subsection 1 of the IFC Court rules and procedure, which reads as under, where a party entitled to cost is also liable to pay cost, the court may assess the cost which that party is liable to pay and either set off the amount assessed against the amount of the party entitled or delay the issue of certificate for the cost to which the party is entitled. And as you are fully aware, Your Honor, actually the idea behind the cost consolidation and our agreement to attend was to discuss actually the remaining amount of the cost. You have ordered us earlier, Your Honor, to pay 50% of the cost, which was made. So the remaining 50% that need to be discussed, and whatever also amount due to our client that should be also actually assessed. We could make this meeting very short and straightforward, rather than go through some thousands of bundles, which we have already gone through it in the past, and I don't see any reason to repeat that. I think the order of the judge is very clear. In case both parties not accepting the cost, the registrar may take the call, and we believe in your wisdom to decide on the cost at the end of the hearing.
Mr. Anderson, would you like to respond?
Yes, Registrar. In my submission, this submission made by Mr. bin Herz proceeds on an erroneous interpretation of your order for the payment on account of costs. So, as you may recall, what happened was that the parties wrote to the court in the middle of last year asking, in relation to the costs order in the substantive trial, for either a summary assessment of those costs, or Al Tamimi asked in the alternative whether you would make an order for 50% of those costs claimed at the time to be paid on account, with the remaining sums due to be subject to detailed assessment. And that is the order that you made. It is at, I think it's page 256 of the bundle, if you have the most up-to-date version. Which I think was filed last night, Registrar.
Let me have a look. I've been working off the earlier bundle. Okay. Can I have the page reference again, please, Mr. Anderson?
Of course, it's internal page 756, which on the PDF itself is page 761. So this was the order you made after the parties wrote to you, and it's on the second page, paragraph 1 of your order. The sunset parties were ordered 50% of their costs on account, in the amount of 537,000 or so dirham. And subsequent to that, you obviously will recall there was some correspondence, and you listed the detailed assessment of the two sets of cost orders. In my submission, there There's no sense in which that 50% figure is binding as to the remainder of the costs that we are entitled to claim. Firstly, because we have obviously since then carried out the process of instructing cost draftsmen to put together the remaining figures. So that's one point. The second point is that those costs that were paid on account were only in respect of the costs of the substantive trial, and they don't include the costs of the committal application, which also form part of the sunset party's detailed assessment proceedings. So in my submission, Mr. Ben Herz, it isn't right to say that we are limited to only claiming another 537 or so dirham. We've now had a bit of cost prepared for the remainder of our costs, which we're entitled to have assessed as per your order. And in addition, we have the cost of the committal application, which require detailed assessment as well.
Okay. Does that clear things up for you, Mr. Ben Herz?
It is not very clear, Your Honor, but let me raise one point here, because no costs were ordered in favor of any parties after that order. Okay, even in committal proceeding, no order on costs was passed. Please look into page 273.
273 of the bundle?
273, please. Yes, please. And this is passed in the committal proceeding. You look into number 5. It's clearly stated there shall be no orders as to cost in respect to the first and second applications.
Okay.
So we wonder which cost he's talking about. You know, although that cost being assisted by Your Honor, and you passed that order, and we have actually complied with the 50%. So the remaining is only 50% of that cost, which actually we want to make it short and simple, reconcile it against whatever amount is due also to our client. And I think we have to close this for God's, because this proceeding has been taken now more than 4 or 5 years. I am not really aware, and I forgot mostly of this, whatever in the case. So we have to put an end for it. It cannot go further, I think.
Mr. Ben Herz, the 50% order on cost, that's cost on account. So the costs have not been assessed yet. So, and that, according to Mr. Anderson's submission, is the cost for a trial. I'll wait to hear from him on the costs order on the committal application. But those costs, by that order, by no means does it mean that only 50% is outstanding. So the costs have not been assessed. So I think the understanding you have is not correct insofar as it's only 50% that's outstanding from that amount. The costs need to be assessed, so they might be more, they might be less.
That's okay.
Okay. Mr. Anderson, would you be able to address the court as to the committal application, please?
Of course, Registrar.
Or the cost of the committal order.
Of course, Registrar. So if you remain on the page that Mr. Ben Herz took you to, which is pages 272 and 273, if I could ask you to look at the first and third recitals to that order, you will see that what that order concerned was firstly an application to vary in order of Justice Sir Jeremy Cook, dated 4th of August, and then secondly an application that the defendant have her contempt purged. So this was actually an order that was made after the committal order itself had been made, and it was on the 8th of December 2022. The order which gives rise to the second aspect of the sunset detailed assessment proceedings is at page 281 of the bundle.
Yeah.
And this is the order dated 23rd of September 2022. And again, if I could ask you, please, to look at the first recital, which states that the applicants are seeking a committal order, and that's defined as the application. Then if you go to paragraph 4 of the order itself, the defendant shall pay the claimant's costs of the application on the standard basis to be assessed by a registrar if not agreed. And that application, as that recital makes clear, is the committal application. So in my submission, Registrar, it's clear there is an order for the costs of the committal application, and those were ordered to be assessed by you if not agreed.
All clear from my end. Mr. bin Herz, unless there's anything else you'd like to raise with the court, I think this settles as to what we're looking for.
Was there any order granted after that?
I'm sorry?
Was there any order granted after that in terms of cost?
I'm not sure if that's a question directed to me or you, Registrar, but in my submission, it's...
I think to you.
I'm grateful. In my submission, any subsequent orders aren't relevant. The terms of that order were clear. The application was the committal application, and the court made an order for the costs of that application. With respect to my submission, Registrar, whatever subsequent orders may have been made, they're not the subject of this hearing today.
Anything else, Mr. bin Herz?
I believe in accordance with the DIFC rule, any cost assessment has to be actually submitted before the court within 3 months of the order. So if they have delayed on that, okay, so I can't understand why they bring that subject now. And by the way, both parties are late on the submission. Let me put it also very clear.
Yes, Registrar, we understand that. As you will know, Registrar, both parties filed these applications after the 3-month period, and the registry did in fact take steps to discontinue both of them, and both parties then applied for continuation orders in respect of both sets of proceedings. Both of those applications were successful, and the parties then agreed in December of last year for these 2 sets of proceedings to be consolidated. So before now, neither party has taken any sort of issue with the fact that the assessment proceedings were not begun in time, and the court has already considered that fact in the context of the continuation application. So in my submission, that shouldn't have any relevance to the questions before you today.
I think this is incorrect because both parties did not agree. Okay, that has to be continued. I think we agreed for the consolidation based on the remaining amount, and that was clear, I think, which we have addressed it to the court. Based on that, we would accept the consolidation, and that's clear in our email, which has been addressed also.
Mr. bin Herz, if you can look at the order of the Assistant Registrar, Delvin Sumo, Haley Norton, issued on the 18th of October. It's very clear that the continuation application is granted. So the court has already dealt with this.
Okay, let it be. Now let us see. Then I think let us go through that.
All right, Mr. Anderson, if we could commence the assessment, please.
Yes, Registrar, I'm grateful. Unless it would assist you in particular, I don't propose to take you through any of the detailed facts of the background to this dispute, because it's not particularly relevant to the questions before you today, and we do have a limited amount of time to get through what could potentially be quite a large amount of material. What I ought to do, you've seen the committal order. Could I just show you very quickly the order of Justice Giles, which gives rise to the obligation to assess in respect of the trial? That's at page 216 of the bundle.
Sorry, 200 and?
214, 214.
214. Mm-hmm.
And it's the second page of that order, paragraph 5. Now, just one point to note on this, Judge. You would have seen from our bill of costs that we've split it into 4 parts. The first 3 parts concern the trial, and they are sort of subdivided according to the timeline of the trial when the 2 sets of claims were consolidated together. For those 3 parts, it's this order that applies, and it's both defendants who are jointly and severally liable for the costs that you order today. For the committal application, it was only Miss Herz who was subject to that order. So the costs contained in Part 4 of our bill of costs will only apply to Miss Herz because she was the only party to the committal application. So I just wanted to clarify that at the outset. So with that said, Registrar, I just wanted to say a quick word about some of the relevant legal principles and how the Sunset parties envisage the detailed assessment process working, subject, of course, to what is most helpful from your perspective. The first point to note is that all of the orders to be assessed today, both in terms of the Sunset assessment and the fixed cent assessment, are orders for costs to be assessed on the standard basis. That, as far as I understand, is not a point that's in dispute. And I have set out the relevant guidelines or the relevant principles in relation to standard assessment at paragraph 20 of my skeleton argument. The main point being there that the court must have regard to all the circumstances in deciding whether costs were proportionately and reasonably incurred and also proportionate and reasonable in amount. So that in my submission will be the sort of guiding principle as we go through the numbers in the bill. The second point relates to the sort of procedure of today itself and how we ought to tackle these bills of costs. And the DIFC court has given some guidance on how that process should work. Could I please ask you to turn up the decision in Melody and Melance, which is at page 568 of the bundle? The head note is at 558, but the relevant paragraph for today's purposes is at 568. It's paragraph 78 of the judgment, where in this case, the Court of Appeal was assessing an appeal from a first instance assessment of cost, and it took the opportunity to set out some guidance on how the detailed assessment process should work. And essentially what it does there is adopt the guidance that the English Court of Appeal gave in Western Stockport NHS Foundation. So that sort of paragraph, if I could ask you to sort of skim over that paragraph in the middle of the page, Judge, that excerpt, it essentially sets out a sort of not a hard rule, but a guidance on how the assessment ought to take place. And essentially what it recommends is that you, Registrar, as the assessing judge, go through the bill item by item, assessing reasonableness per each item, and then adding those figures up and coming to a view as to reasonableness and proportionality at the end. Now, in my submission, that will be an appropriate process to follow in respect of the fixed cents bill of costs, because Al-Tamimi have set out in detail on an item-by-item basis why they dispute certain items that are included in that bill of costs. However, our primary position is that that is not going to actually be a fruitful exercise in respect of the Sunset bill of costs, because the points of dispute fail to comply with the requirement that disputes have to be raised in relation to individual items. And that was the third point I wanted to come on to. You'll have seen it was a point I raised in my skeleton argument. And it's essentially the question of what must a party include in their points of dispute so that the court and the paying party is able to actually work out what it is they are saying is unreasonable or disproportionate. And there are 2 cases from the English courts, which are fairly recent decisions, which help to explain what it is the points of dispute ought to do and the content that they ought to include. The first of those decisions is Ainsworth and Stewart's Law LLP, which is at page 542 of the bundle. And if I could ask you to just quickly turn that up, please. So, Registrar, this was a solicitor and own client assessment rather than an inter partes detailed assessment, but there's no suggestion that the principle should be any different because, in essence, the court is doing a detailed assessment on both in both cases. And can I please ask you to turn to page 547, which includes the bottom of 546, top of 547. It's paragraph 10 of the Court of Appeal's judgment. And what the Court of Appeal does there is it sets out the reasoning of the first instance judge, the Chief Master, in relation to a specific point that had been raised as to the detail included in the points of dispute. And again, if I could just ask you to skim over in particular paragraphs 9 and 10 of the Master's judgment. What he essentially says is that the difficulty that the paying party had in that case was that the receiving party had adopted a very broad brush and they hadn't gone through the bill item by item to actually say, you know, you've claimed 1.5 hours for this, we only offer you, 0.2 hours for this item on an item by item basis. And the Master said that that was the wrong approach because it didn't allow the paying party to properly assess what was being challenged and sort of put forward a justification for those sums. And the Court of Appeal agreed with that approach. So it followed from that was the sort of source of the rule that there ought to be an item by item breakdown in a points of dispute. But one of the questions that judgment gave rise to was what's meant by item? Is it the item in the bill of costs itself? Or does it have to be the items in the schedule, which are obviously more particular than the item in the bill of cost? And the answer to that was provided last year in the decision of O'Sullivan and Holmes and Hills, which is at page 578 of the bundle. And if I could ask you to just turn that up briefly as well, please, Registrar.
Yes, Mr. Anderson.
Grateful. It's page 582 of that judgment. In fact, first, could I ask you to, look at 582. This is quite important. You'll see at the top of the page there's an excerpt from what the receiving party included in its points of dispute. And I'd ask you to bear that in mind, because when we come to look at the points of dispute on the Sunset Holdings assessment, what we have in our case is very similar to what the receiving party had put forward in this dispute in O'Sullivan and Holmes and Hills. And the court ultimately held that this wasn't sufficient, it wasn't enough detail, and that on that basis, any disputes in relation to those particularisations had to be dismissed because they weren't properly particularised. And you can see the sort of style that was employed there. It was essentially partner 11.1 hours claimed, 8 hours offered, and the only reason given is unreasonable in amount. And the point taken in the reply was that the dispute isn't compliant because the defendant isn't in a position to identify which fees are actually in dispute. And the court was invited to dismiss the points of dispute on that basis. And then, just in terms of what the court decided, Registrar, the most important paragraphs are 43 and 49. 43 is on page 594 of the judgment. Essentially what the court was doing here was rereading the Court of Appeal's decision in Ainsworth and Stewart's Law to work out this point as to whether or not it was the item in the bill that the Court of Appeal was talking about or the item in the schedule. And what the High Court clearly says is that it's the items in the schedule that you need to identify and dispute on an item by item basis. That's what's said at paragraph 43. And then at paragraph 49, 2 pages down, the judge says this: on my basis of my interpretation of the judgment in Ainsworth, the points of dispute in the current case do not satisfy the requirements of the relevant English practice direction, in that they do not identify specific points stating concisely the nature and grounds of dispute. The receiving party cannot identify which individual units of work are disputed and why. So I draw that paragraph in particular to your attention, Registrar, because when we come to now look at the bill of costs itself, there are 2 of the 7 points of dispute raised on behalf of the fixed sentence parties, which we say fall into this exact same trap, as it were, of not giving us sufficient detail to understand which items in the schedule are being disputed. And I'll identify those as we go through the bill of costs. But in a nutshell, we will be asking you to dismiss those particular points of dispute on the basis that they are non-compliant in accordance with these 2 English authorities. So then, Registrar, that then brings us to the bill of costs itself and the points of dispute. As I said at the outset, our primary position is going to principally on this assessment be to go through the points of dispute rather than the bill of costs on an item by item basis, because our primary position is that these are only general objections. Yes, so we'll be giving general responses. But to the extent that you would like me to take you to any items in particular, please do let me know. But it's somewhat difficult just having the 1 page on the screen because we can't look at the bill and the points of dispute at the same time. So I'll go through the points of dispute, but please do let me know if it would help to take you to any of the items in the bill.
Points of dispute are fine.
Yes, okay, so those are at page 410. They start at 410. And it may be most helpful, Registrar, for us to go through the relevant disputes one by one, with myself and Mr. Herz sort of giving you our submissions on that and you giving a ruling in relation to each point. I don't know if that would be most helpful from your perspective. Yep. I'm grateful. So the first point, we've put a preliminary point there. I've already gone through that. That's the Ainsworth and Stewart's decision. So I don't need to trouble you by going through back with that. The first general point is at the bottom of page 412. Now, the first box here is the point raised on behalf of the defendants, the fixed sentence parties. They say that they have made an offer of 948,696 dirham in respect of our costs. You'll see in our reply that the short answer to that is that isn't a point that's relevant to your assessment of the costs. The extent to which the parties have made offers prior to the detailed assessment proceedings is only relevant to the costs that are claimed of today. We don't accept that figure in any event, but because it's not relevant to the detailed assessment process, we would simply ask you to sort of disregard that for the purposes of assessing the costs.
Mr. Herz, is there anything you would like to say at this point?
I think we also rely on the judgment filed by Al-Tamimi. This court may consider the legal principle laid down in the ruling addressed by Mr. Anderson, because this all it talks about the principles. The legal principle. And by the way, we have not received any skeleton arguments from them. So there is, I have not seen any skeleton argument.
There is a skeleton argument.
No, we have not received it. So let them show us the email that they send us, and they have filed the skeleton arguments.
My instructions are, Registrar, that we sent an email offering to exchange skeletons, but we didn't receive a response to that email.
No, there was no email. By the way, in regards to the skeleton arguments, And even, by the way, when we call, or even the DFC court, okay, to clarify, they say there is no need actually to submit skeleton arguments because it's a straightforward issue. This is our understanding. And so show us the email that you have asked us to exchange a skeleton argument, because you should put it as part of the bundle.
Mr. Ben Herz, just from the court side, the email listing the hearing set out a deadline for the filing of skeleton arguments.
Yeah, but we didn't receive it, Your Honor. The skeleton argument.
Yes, but I'm just responding to the point
yes,
you made in
okay,
regards to the court saying a skeleton argument was not needed because we clearly directed that one be provided by 4 p.m. on Friday, the 12th.
But we have not received any from them. This is my actually answer to your. Okay.
We can clarify
so
that. Mr. Anderson can clarify
so
that.
Your Honor, you may allow me 1 minute, please treat our points of dispute as argument for consolidation. We will not take any further of the court's time.
Sorry, could you repeat that argument, please?
Yeah, treat our points of dispute arguments for consolidation. In order not to take much time of the courts.
Okay. Mr. Ben Herz, so what's happening right now is that Mr. Anderson is taking us through the points of dispute where you have made your arguments there. And what's going to happen is we're going to make a decision based on what's being said. So do you have the bundle in front of you?
Yes, we have the bundle, yes.
Okay, so we're at page, I believe this is 413 right now. So, Mr. Anderson, just for the benefit of Mr. Ben Herz, could you sort of take us through that submission again?
Yes, of
just
course.
So we're on the same page. Yeah.
Of course, yeah, Registrar. So the point, as we understand it, that the defendants are making is that an offer was made to settle our costs in the region of it was around 900,000 or so, around 950,000 dirham. We don't accept that figure is correct on what the letters actually say, but that's sort of by the by. What we say is that whatever offers were made are not actually relevant to the assessment of the costs, that it's relevant to the costs of today's hearing, which are obviously two conceptually different things. The simple submission is that as a preliminary point isn't relevant to what you are doing, Registrar, in terms of working out whether our costs are reasonable and proportionate.
Mr. Ben Herz, would you like to respond to that point?
Just a minute, please. I think this is being filed 6 months back. Okay. To be honest, I don't have a clear answer to that now.
Okay.
Yeah.
That's fine. We can move on to the next point.
I'm grateful, Registrar. But so just to clarify, should we take you through the points and you will give a ruling in relation to each of the preliminary points at the end? Yeah. I'm grateful. So then the next point is one about the size of the legal team, as it were, the legal representatives. This is general point 2, which begins at the beginning of page 415. You can see 2 points are made there in relation to the submission that the number and seniority of fee earners was grossly disproportionate in light of what the defendants describe as the simplicity of the matter at hand. Firstly, identified that we had 14 separate fee earners, including Mr. Essam Al-Tamimi himself. And they criticised what they described as an exorbitant rate of 10,000 dirhams per hour. Then the second point being that most work is performed by Mr. Dylan Malone and Mr. Brooks, who are both senior counsel, and they say that some of that work could have been delegated. Now, the first point to note about that, Registrar, in my submission is that those are points being made on a general basis. Really, in order for them to have effect, the defendants would need to make those points in relation to particular items. So it's not particularly helpful from your perspective in my submission to sort of just make general points about that, because this is a detailed, not a summary assessment. But in any event, in relation to the points made there, there does seem to be in my submission something of a fixation on Mr. Al-Tamimi's hourly rate himself. That was discounted in the bill of costs anyway to 6,000 dirham. But in any event, of all of the hours claimed, only I think it's 2 hours of the sort of hundreds of hours claimed relate to Mr. Al-Tamimi himself. So that's the first point. The second point in relation to the use of Mr. Dylan Malone and Mr. Brooks, well, we don't accept the premise of this criticism, which is that this was a simple matter, or it's described as the simplicity of the matter at hand. This was a complicated dispute involving quite complicated financial documents in relation to particular shareholdings. There were allegations of misrepresentation that were made in the counterclaim, and ultimately these were high-value proceedings. The shares themselves were high value, and the stakes therefore were significant. So we say that in those circumstances, these aren't simple proceedings. The sunset parties were entitled to employ senior counsel to do a significant share of the work because they were complicated, high-value proceedings. But in any event, but part of what's relevant in terms of the deployment of senior counsel is the behaviour of the other side as well. And we've quoted in our points of response there a particular paragraph from the trial judge's judgment, Justice Giles' judgment, who describes the evidence of Miss Al-Herz as nothing other than a concoction. So in other words, this was a case that involved a dishonest witness as well. And in those circumstances, it was appropriate in my submission for more senior counsel to be involved with those very important points. And then, of course, you've seen from my skeleton argument the steps that were subsequently taken by the fixed-sentence parties, which ultimately led to the committal proceedings being initiated, in the sense that the fixed-sentence parties deliberately tried to, in a sense, frustrate that judgment and avoid the orders for the transfers of the shares. So in my submission, that takes much of the sting out of those criticisms. And the final point to note is that the number of fee earners itself is not of itself really a criticism. It's really sort of the deployment of those fee earners that's relevant. Whether or not you have 1 or 14 fee earners, that itself is not a criticism. It depends on how those people are utilised. And I've given you the example of Mr. Al-Tamimi having only been used for a very, very small portion of this claim. So in my submission, we don't accept that criticism. We say that the use in particular of Mr. Dylan Malone and Mr. Brooks was proportionate and was reasonable, given the complexity of the matter, the high stakes of this claim, and the ultimately the allegations of misrepresentation and points of dishonesty as well.
Thank you. Mr. Ben Herz?
Yeah, just give me 1 minute. I just want to calculate the number of hours. Okay, they have claimed. We divided by 22. Okay. So, okay, no one worked 20. Okay. First of all, the amount of time claimed by Al-Tamimi is simply incomprehensible. They just want to inflate the bill. Whatever type of matter this was, the hours claims in the name of Mr. Mellon and Mr. Brooks is 537 hours for 22 days. Is it even possible? Does it look reasonable? Of course not. And by the way, Mr. At-Tamimi was never involved in the case. Even after that, when we had a discussion with Mr. At-Tamimi outside the court for settlement, he has no clue of the case. So I can't understand how they put also he was involved in the case, which he don't know anything about the case, by the way. And he was never a peer of any point of time. So this shows clearly they have just adding hours in order to raise their bill. And how it worked, 537 hours in 22 days, they are working 24 hours per day. Of course, it is impossible. So this shows, this actually bill of cost, which they have submitted, is not reasonable, Your Honor. We have to be fair when we claim cost.
Yes, Mr.
Registrar, yeah, I'm great. Just to come back on a few points there. I have to protest the allegation that my instructing solicitors are deliberately inflating the bill. That strikes me as coming close to an allegation of professional misconduct in the submission of bill of costs, and we do strongly refute that. We've set out in the bill itself we've put out particulars of every single hour claimed. In relation to the submission that this is a lot of hours, the simple fact of the matter is this was not a simple dispute. You will have seen from the bundle itself that there were some 134 pages of pleadings alone before we even get to the 2 years that elapsed following the pleadings closing and before trial then occurs. There is one point that I should make in relation to Mr. Dylan Malone in particular, which is that he was also the lead advocate during the trial itself. So the costs claimed on behalf of Mr. Dylan Malone will be his costs as a solicitor acting in the course of these proceedings, but also sort of the equivalent of what would be paid to external counsel to conduct the trial as well. So his costs do comprise those two things. Just in relation to Mr. S.M. Al-Tamimi, I've set out in my skeleton the particular items of the cost bill to which his hours relate. It's items 24, 51, and 75.
That's in the bill.
That's in the bill, yes.
I'm looking at your bill of costs right now. Item 20.
It's 24, 51, and 75.
I don't see. Do you have a page reference, Mr. Anderson?
Let me. I'll just get it up, Registrar. I'm sorry. Yes, so it's page 297.
That's fine.
Is the first one. And you'll see item 24, E80, SM Al-Tamimi engaged 0.5 hours.
And this is for work on documents.
This is for work on documents. So if you then go to Schedule 6, which is at page, it starts at page 316. You'll see that EAT, there are a couple of entries on page 320.
Sorry, so not 316.
Sorry, that's where Schedule 6 starts, and then it's quite a long one.
320.
It goes to 320, exactly. In the middle of the page, you'll see 3 entries around the middle of the page, 20th of September, and then 23rd and 27th. First one, discussions with team regarding latest settlement proposals. and views on appropriate action and potential avenues to dispose of those proceedings. So, in other words, sort of high-level strategic discussions about settlement, for which Mr. Al-Tamimi, as chairman of the firm, is very well placed to assist with. And then the next ones are discussing settlement strategy as well. So it's only half an hour's worth of time on that item. I mentioned as well there were two other items in relation to which Mr. Al-Tamimi's time was claimed. Those were items 51 and 75 on the bill of costs. So I'll just get a page reference up for you for those. So the item 51 is at page 301, Registrar. What I'll do, I'll show you these two entries before then going to the schedules to save having to flick back and forward through a lot of it. But item 51 is attendance on clients, is a timed attendance and schedule aids at 1 hour at the discounted rate of 6,000 dirhams per hour. So that's schedule aids. And then the only other item is item 75, which is on the next page. Again, that's work on documents, half an hour, and that one's in schedule 11. So if we go to schedule 8 first, which is, it begins on page 322, and Mr. Al-Tamimi's 1 hour is on page 323. 1st of October 2020, meeting client to discuss issues arising from the fixed sentence claim and the progress of negotiations. So again, his sort of involvement is just limited to the settlement discussions. And then schedule 11, Mr. Al-Tamimi's time is at page 326, about halfway down the page. 1st of October 2020, discussions with team following meeting with clients, going through key issues raising fixed sentence claim and impact on wider negotiations. So and half an hour. So they are times that have been properly particularised, but in any event, it's important not to get lost in this point and to see the wood through the trees. These are 2 hours worth of time in the context of the entire bill. I won't press too hard for the whole of those hours, but in my submission, this is a very small point for the defendants to be making in relation to what is a significant bill. I've taken you to those entries to show that they were properly incurred. Obviously, Registrar, it's a matter for you as to whether or not it was reasonable and proportionate for the chairman of the firm to be used for 2 hours in the context of this dispute. We say it was because A, those were very short hours, and B, this was a high value and complex claim. And I don't think I can sort of put it any higher than that.
All right, so Mr. Anderson, if you could instruct your instructing solicitors to reduce the hourly rate for Mr. Al-Tamimi.
Yes.
To the highest rate and the indicative hourly charges set out in the Registrar's Direction number 1 of 2023, and that's about, I believe, just slightly over $1,000. If we could maintain the rates that were set out in that Registrar's Direction, I doubt that it will make that much of a difference anyway, given the minimal amount of hours that Mr. Al-Tamimi has interacted with the case.
Absolutely, yeah, Registrar, we'll certainly do that. It's yes, 3,746 dirham per hour. I think that's right, isn't it? From the
yeah, so 1,000, I believe 1,020, if I'm not mistaken.
Yes, that's yeah.
And that will take, minimal reduction in the bill.
Yes.
Okay, and then we can move on to the next point.
Yes, so the next point...
Sorry, Your Honor, this point is not very clear. And just also, I want to elaborate, we are not making any allegation of misconduct, but it does not appear plausible or reasonable to put in 537 hours in one case alone, which was not answered by him.
Registrar, I think you have my submissions on that. This was a case that took place over the course of 2 years. It was complex. It was high value. Those hours were, in my submission, reasonable in the context of a 2-day trial. And in addition, the other point as well, Judge, is that obviously these were 2 different sets of proceedings that were consolidated together. There was some overlap, but to some extent, you can divide it by 2, and it's sort of 225 hours per case, which is less than sort of 10 full days per case.
Make this short. I will leave it to the registrar wisdom to make a decision on this.
Thank
Because
you.
I think it's better not to go into too much argument. Otherwise, I think we will never end. So your wisdom, registrar, I think we will take that.
Moving on to the next point, please, Mr. Anderson.
I'm grateful, Registrar. So this is now page 416 of the bundle. Bottom of page 416, top of page 417. This is a point which I think I can deal with quite shortly, because it's something that you yourself touched on at the beginning of the hearing, Registrar. A point is made that obviously in the context of that correspondence we were looking at the beginning of this hearing, we obviously had estimated our costs as being just over 1,100,000 dirham. And it was on that estimate that you made the order for the 50% order on account of costs. The defendants seem to take a point that obviously we've claimed slightly more costs in this bill of costs, and I've already given you the 2 reasons for that. One is that obviously it's now been subject to proper preparation by cost draftsmen, so all of the sort of relevant points have been picked up. And the second point is that it now includes the cost of the committal application, and you've already given your indication on that. So I don't propose that I need to say anything more on that point.
Okay. Mr. Herz. Do you have anything to say on that point, Mr. Herz?
Yeah, there is no order granted in terms of cost on the committal order. So I can't understand why we bring that into the subject of the discussion of the assessment cost today.
I think I've already made my finding on that.
Each party should bear its cost. And there was no cost order.
I've already made a finding on that, Mr. Herz. The committal order, the order dated the 23rd of September, if I'm not mistaken on the dates, sets out the order for costs on the committal application. We touched upon this at the beginning of the hearing. So your arguments here are that the costs are not reasonably incurred and they're not reasonable and proportionate in amount. Anything further to add before we move on to the next point?
No, there is nothing to add.
Let's move on.
Registrar, I'm grateful. So the next point is point 4, that's page 418. This is the first point that engages that legal sort of principle that I was going through earlier, the O'Sullivan and Holmes and Ainsworth and Stewart's point. You can see here that what is said on behalf of the defendants, on behalf of the fixed sentence parties, is time done on documents is neither reasonable nor proportionate. To some extent, this obviously overlaps with the point that we were discussing in relation to point 2. But the sort of broader point is that, as you can see on the side, certain items in the bill, not in the schedule, in the bill of costs have been identified in the brackets there. It's by my count, it's 22 separate items in the bill. And then on the right-hand side, there are 4 broad disputes raised in relation to reducing hours claimed in the schedules. Now, in my submission, I took you earlier to the excerpt from that defective points of dispute in the in last year's English High Court case. This is almost the mirror image to that. It's exactly the same format. And in my submission, it hasn't allowed my instructing solicitors to go through their schedule and work out in particular what items that we're claiming costs for are disputed. We just haven't been able to do that exercise because the fixed sentence parties haven't identified which items in that schedule they say are unreasonable or disproportionate. So in my submission, this point can't go any further than the point that's already been raised, which is a general one in relation to the hours, the total hours claimed being unreasonable and disproportionate. And Registrar, you have my submissions on that point. So in my submission, to the extent that this differs at all from that previous point, it should be disregarded because it doesn't comply with the guidance of the English High Court in O'Sullivan and Holmes and Hills.
When Herz.
We reiterate at this point that they have taken 538 hours. This is not reasonable, nor appropriate.
Mr. Anderson, my only question on this point relates to, I mean, specifically you've already touched upon this point where Patrick Dillon Malone does the advocacy, but also does some of the solicitor drafting. Does the same apply for Mr. Brooks?
Let me take instructions from Mr. Brooks, who is in the room. No, but so Mr. Brooks didn't do any advocacy, so his times will be sort of quote unquote pure solicitor costs in the bill of costs. It was just, I think Mr. Malone acted as sole counsel during the trial. So yeah, Mr. Brooks' costs are sort of pure solicitor costs.
I mean, I'm not aided by any submissions from Mr. Ben Herz on whether or not these the documents could have been done by a junior fee earner rather than having senior counsel working on those documents. That would have been helpful, but
yes, Richard, as I say, if the difficulty from our perspective is that had sort of individual documents been identified in the schedule, then you would have been able to work out whether it was appropriate for that particular document to have been worked on by someone more junior. And that seems to be the tenor of what those English cases say, is that if you don't do that, then unfortunately your points of dispute can't stand, because it's impossible for the registrar to be able to work out what documents are said to be have been disproportionately worked on by someone too senior.
okay.
So if there's nothing further on that.
Sorry, but let me comment on this point, if you don't mind, please. Okay, this could have been done by the junior counsel, because this is not, and I'm saying that this is not possible. It will actually take 537 hours. See, we are working all in the same field, and honestly, this is not possible at all.
If I could sort of just clarify or shed some light on where sort of my thoughts are leaning towards, I don't see 538 hours, almost 539 hours, to be an unreasonable amount given the amount of time this case has taken and given the nature and complexity of the dispute. My issue is I am not aided by any submissions from you, Mr. Ben Herz, on that would allow me to examine what these documents are and whether or not they could have been drafted by a junior fee earner rather than having Mr. Brooks and Mr. Patrick Dillon Malone drafting them with their obviously higher rates. So the issue that it's not the hours for me that I deem unreasonable or disproportionate. They seem proportionate enough. My issue is whether or not the documents could have been done or drafted by someone more junior, thereby lessening the amount.
Yes, now I'm making this submission.
Registrar, if it's helpful, just one very small point on this. I've just been instructed by Mr. Brooks that He was actually a senior associate on this matter until around January 2022, when he then became senior counsel.
So these rates. So his rates in this bill relate to when he was a senior associate.
I think it's a sort of a split between the two.
Okay.
Because it's a single rate used. It may be, I'm instructed, Registrar, that for the committal application, certainly it would have been the senior associate, the senior counsel rates used, because Mr. Brooks was senior counsel by then, and also for the trial as well. But anything predating that would have been at senior associate rates.
And what is his experience rate, Mr. Anderson? So his level of experience.
15 years, I'm instructed. Now, at the moment, so it would have been 11 years when the case first started, 2020, 11, 12 years.
Okay, so he would be around the, I believe, $900 figure per hour, according to the indicative hourly legal charges. I'm assuming his rates are within that, because I didn't find anything in your bill of cost that takes you over, other than Mr. El-Tamimi's hourly rate.
I'm sure that's right, Registrar. Yes.
Okay, so for these items, Mr. Anderson, I'd like to apply a discretionary deduction of 20%.
Yes, is it which items in particular is this?
So the item set out in point 4 for work done on documents.
Sorry, Registrar, could you just give me 10 seconds? I just need to get the page. So I see. So 20% to the hours claimed in schedules 6, 11, 15, and 21. Is that right?
Mm-hmm. Mm-hmm. I'm going to leave it to you, Mr. Anderson, to come up with a final figure.
Yes, would it help, Registrar, if obviously it's all time dependent, but we can do the arithmetic after the hearing and submit it.
Yeah. Yes, please.
I'm grateful. So that's if unless I can assist you further on that probably takes us to the next point.
Yes.
Which is a point about the preparation of the bill of costs itself. Point 5.
Okay.
The page reference, Registrar, is 419.
Yeah, I'm with you.
It's again, it's something of a generic objection. The paying parties say that the cost consultant's time should be reduced to 20 hours in relation to the trial section or the sort of the substantive proceeding section of the bill of costs, i.e. parts 1, 2, 3, and then reduced to 4 hours in relation to the committal application. Again, it's one of these points that you've already made, Registrar. We're not particularly assisted by any submissions on why those figures are said to be excessive. But one of the points we've made here in the point of reply is that the actual fees charged in respect of preparing this bill of costs only amount to 4% of the total costs claimed, which in my instructing solicitor's experience is below the typical sort of percentage of how much it costs to prepare these. You would have also seen as well that it's obviously a highly detailed document. You've had to go through it yourself, 65 pages with 1,000 time entries over the course of 2 or 3 years worth of proceedings. So in those circumstances, an offer of 24 hours, which is sort of 2.5, 3 working days, we say is unrealistic for preparing a 65-page document with 1,000 separate time entries. And our submission is that it just wouldn't be possible to prepare this document in the time offered. And so our position is that no discount should be made in respect of this.
Mr. Herz. Any submissions, Mr. Herz?
Sorry, just 1 minute, please, if you don't mind. We believe this timing is unrealistic because it will not take 1,000. I think what we are offering is reasonable. Can you prepare a 65-page for 1,000 time entries? Especially they are fully aware of what's going on. This is only preparing a bill.
Anything else, Mr. Herz?
Nothing else, Your Honor.
I'm fine with these charges, Mr. Anderson. We can make them and no discount to be applied.
I'm grateful for that, Registrar. That then takes us to the next point, which is point 6 on page 420. This is a very broad point. The point made here is that no supporting details are added in relation to routine correspondence, which apparently raises doubts that such costs have not been incurred reasonably nor proportionally. And you're asked to disallow all of our costs for routine correspondence on that basis. In my submission, that's plainly unrealistic, and that's not how these bill of costs work. You'll know yourself, Registrar, that the distinction is made between attendances for correspondence on the one hand and routine correspondence on the other. And it is routine correspondence is by its nature routine, so there's no need to sort of provide great particulars of that correspondence beyond the number of items claimed. This is usual practice. This is what normally happens in these bills in my submission. And no doubt, had we instructed the cost draftman to provide particulars of those 20 or 30 routine correspondence bills, we'd be facing a complaint, as we already are, that the cost draftsman has spent too much time preparing the bill. So in my submission, it can't be the case that all routine correspondence has to be taken out because we haven't said what the routine correspondence relates to. It's routine correspondence. It doesn't require any more than that, and to remove it entirely from the bill would be unreasonable and disproportionate. And I would note as well that there's no allegation is made as to sort of disproportionate or reasonable time spent on those matters. It is essentially the only point made is that the whole thing should be taken out, and we say that that's blatantly inappropriate and inconsistent with this court's approach to detailed assessment and the assessment of routine correspondence.
Mr. Herz?
Yeah, we have no submission on this, but when it comes to our correspondence, we would request you to apply the same rule.
Well, we have no objection to that, Registrar.
Then let's allow them. Okay, we allow routine correspondence for both parties.
I'm grateful, Registrar. And then that then brings us on to the final point for the sunset assessment, which is point 7. this is an allegation that we say again falls into the trap of not properly identifying the items in the schedule. But in any event, you can see the point being made here is that the costs claimed by Mr. Dylan Malone, they are described as being exorbitant, where those tasks could have been apparently more efficiently and conveniently delegated to an independent barrister. Obviously, a reference is made to the instruction of Mr. Matthew Watson for £12,000. Obviously, one needs to be careful there. Mr. Matthew Watson was instructed for the committal application, which was a much smaller hearing and application compared to the trial of both of these claims, which is what Mr. Dylan Malone did. So, to some extent, it's comparing apples and oranges to compare Mr. Watson's brief fee for his committal application with the costs incurred by Mr. Dylan Malone for a 2-day trial of 2 heavy, complicated claims. But in any event, even leaving that point aside, we say that there's nothing in the narratives that suggests that there's been any duplication, as the paying parties seem to suggest. That they say that repetitiveness of Mr. Dylan Malone's time entries and generate doubts that they're not reasonable nor proportionate. The preparation for and attending the trial and preparing the skeleton argument at 134 hours, we say is sort of perfectly reasonable and proportionate in the circumstances. It was sort of the bulk of the work that needed to be done in relation to the trial itself, and it included drafting the skeleton argument, which was itself a complicated and long document as well. So that's the point on that. And sorry, the other point as well is that it's obviously commensurate to, as we say, the complexity of the issues in dispute. This wasn't a case where it would have been appropriate, in other words, to instruct someone relatively junior to conduct the trial, because senior counsel were required, because it was a complicated case. There were complicated points of law and serious allegations of misrepresentation, etc. It was, in short, appropriate for Mr. Dylan Malone to conduct the amount of hours he did in preparing for trial. So I don't think I can assist you further on that point, other than to sort of make again the point that this hasn't been done by reference to the particular points in the schedules. It's done at section I there by the reference to some of the times claimed on dates. So it may be to some extent that you would be assisted by looking at those dates, but other than that, we say that this is, again, a very generic objection, and it's quite difficult for us to pinpoint exactly what is said Mr. Dylan Malone should or should not have done.
Mr. Ben Herz, any submissions?
See, the repetitiveness of PDM's time and trace and generate doubts, because Mr. Mellon, from beginning, he's fully aware of the case. So we don't see any point to appoint Mr. Matthew, in fact, for the committal order. This is one. Also, regarding the committal application, there are several tasks, such as the drafting of skeleton argument, that appear to have been duplicated by PTM and or GRP, given that the receiving party instructed Mr. Matthew Watson on this application. So I don't think we should actually observe that cost of that £12,000.
Registrar, can I assist you with that, just with some information about why Mr. Watson was instructed? The reason for that, as per my instructions, is that Mr. Dylan Malone had actually left this firm and moved to a different firm in between the first and the second hearings of the committal application. So independent counsel, external counsel was instructed for that hearing of the committal application because Mr. Dylan Malone essentially was no longer available. He didn't work for Al Tamimi anymore. So that's the sort of explanation as to why Mr. Watson was then engaged to conduct the committal hearing, if that assists.
Was there anyone else at Altamimi who could have done the advocacy, Mr. Anderson, at the time?
No, not as much. Mr. Brooks is not an advocate, and Mr. Dylan Malone was the only person essentially who was sort of qualified and in a position to do the advocacy. He did do, as far as I'm aware, he did all of the advocacy that he could prior to moving the firm. And the other point as well, Registrar, is that there was only a short period of time between the two committal applications, a relatively short period of time. So in order to bring someone within the firm up to speed and prepared to do the advocacy, probably would have been, in fact, more sort of less cost effective than employing external counsel to sort of pick up this discrete issue, which was the committal application.
I'll allow the cost for Mr. Watson.
Sorry, Your Honor. This is the first time they are saying this. They have not raised this at any point of time that he has left the firm. So how come, you can allow them this cost? They could have said it earlier in their reply. So maybe then we would review even whatever cost they have actually submitted earlier by him. So
I don't see how that's relevant.
it is relevant because, they have to be transparent, They have charged it, and then suddenly now they come out of nowhere and they say he has left the firm in 2022. So if you would take it, at least I would say maybe you should allow some discount on this rate which they have submitted. I think that should be fair.
I don't think Mr. Watson's cost, my understanding is he only did the advocacy for the committal application, and that was a 2-hour hearing, if I'm not mistaken.
I think that's right, Judge, yes. Registrar.
Was it 2 hours or was it over 2 hours? I think it was 2 hours from my own recollection.
Over 2 hours.
It was over.
My instructions are that it was around 2 hours, might have been slightly over, but it was I think it was listed for 2 hours.
Listed for 2 hours.
Might have been slightly over.
£12,000, Mr. Ben Herz, for an application of that nature. That's not excessive to me. I don't see why I would. And given that Mr. Watson had, I'm assuming, not had any prior interaction with the case, having to come up to speed, it's a relatively sensitive application. I don't see that as disproportionate.
Anyway, we put this.
We can look at the hours that were claimed by Mr. Patrick Dylan Malone and Mr. Jonathan Brooks in regards to this application. I don't have the items in front of me right now. So the hours that Mr. Dylan Malone claimed and Mr. Brooks claimed for work on documents in the committal application, were those already part of the schedules that we looked at earlier, Mr. Anderson?
Let me just check, Registrar. I think they are, but I will double check just to make sure there isn't a separate schedule for the committal costs. I don't think there were. I will check. No, sorry. I think it was actually. So I'm so sorry. I remember that. I think Schedule 21 of our bill of costs, I think, which is page 343, Registrar, I think is the work done on the documents for the committal application only.
Okay.
And that corresponds with. I'll give you the reference for the item in the bill of costs as well. It is item item 158 onwards. So 158 to 161, which is work on documents, Schedule 21.
158.
I think it's the two. I think it's 159 and 160, which you're concerned with, Registrar, on page 309. The total cost claimed by Mr. Dillon Malone and Mr. Brooks in relation to the committed application. It's those figures there of 96,000 odd dirham for Mr. Dillon Malone and then 76,500 for Mr. Brooks.
Sorry, page 306 or 9?
9, sorry.
9, okay.
309, yeah. Items 159 and 160.
159. Okay.
Yes, you have, sorry, Registrar, I've just been reminded, this schedule did also feature in your order to reduce these by 20% as well.
Okay. So we've already reduced these.
Yeah.
Then I won't reduce them any further.
Yeah.
Okay, I will not reduce them any further then.
I'm grateful.
I think you just check when he has left the firm, your registrar, and reduce those, whatever they have claimed from the time that he left the firm.
But we haven't claimed any time for Mr. Dillon Malone after he left, because he had left. So there's no entries included for Mr. Dillon Malone's time after he had left.
But you already claimed it in the committal order, as he is still in the firm.
But so he was still at the firm after the committal application was issued, so he did do work on the application while it was still extant, but he had left the firm by the time of the hearing of the committal application. I hope that clarifies why his costs were included for some of that.
Which date he left the firm, if I may ask?
Yeah, October 2022. Between the first and the second hearing. Yes, we can't recall the exact date. It was between the first and the second hearing of the committal application. At some point between those dates, which to my recollection is at some point between September and October of 2022, I think. Around then.
We need that to be recorded, your register, so we would check,
It's recorded, but we've already reduced whatever we can reduce here. Sorry, we were at page 419, I think, Mr. Anderson, unless I am. Yeah.
A little bit further on, I think it was 421.
421.
But that was the final of the 7 points of dispute, Registrar, raised by the paying parties in relation to the sunset proceedings. So I don't think, from my perspective, I don't think there's anything else I need to say on the sunset ones. You've obviously given us the orders, which we can then go away and compute the new figures. I'm sort of in your hands as to whether or not there's anything else that I can help with on the sunset.
Just your costs for today, Mr.
Yes. Yes. So I will have. I think I've set out in my skeleton that there is a provision of the DRC court rules on this, which is Rule 40.44, and that provides that the receiving party is entitled to his costs of the detailed assessment proceedings, except where there is a provision which provides otherwise, or the court makes some other order in relation to all or part of the costs of the detailed assessment hearing. So the presumption or the starting point is that we are entitled to our costs of today. We filed a statement of costs in respect of the sunset party's detailed assessment. It's in the most recent bundle. Did you?
700. Yeah, I think page 715.
You're ahead of me, Registrar. I'm grateful. Thank you. We seek an order for our costs to be summarily assessed. The total costs we've claimed there are 134,575 dirham and 48.
And these are for the preparation for today and for the attendance.
Yes, it's everything from the bill of costs. So this will include sort of the points of reply will be included in this. It will be sort of consideration of the points of defence. It's not simply, as it were, sort of preparation for the hearing today. It's essentially all costs in relation to the detailed assessment after our bill of costs was filed. So a lot of that work will include the work on the points of dispute as well, and obviously doing the legal research in relation to these these cases, having to try and work through the defendant's objections to some of these items as well. So yeah, so just to clarify, these aren't all costs of today. I can see how that would look disproportionate in those circumstances, but it's all of the costs from the bill of costs being finalled to today, essentially.
I think this should be disallowed because it's been only submitted, yesterday on the evening. And if this is the basis you're allowing this, then the point of dispute also, then we have the right to claim whatever we have submitted on that.
You do have the right to claim that, Mr. bin Herz.
Yeah.
There would be no other time that they can submit this. So this is preparing for today, responding to the points that you've raised. So this is.
Well, I think then the same rule should apply.
Yeah,
on the point
it will definitely.
with the same amount, maybe.
Yeah, and also I will need to have both sides costs for attendance today, so that will come at a later stage.
Sorry, Registrar, just to clarify that our costs of attendance today are included in this as well.
Okay.
This is everything from bill of costs.
This is everything. All right.
Yeah.
To the potential order that will come out.
It will include drafting the order as well.
My only question with this, Mr. Anderson, is there seem to be two different rates for Ms. Jaballa and Mr. Brooks and Mr. Vijayan.
Mr. Brooks is the point that we touched on earlier. Oh no, this.
He changed positions.
Sorry, sorry, Registrar, I apologise. This is a separate point. In January of, I think it was this year or last year. This year? No, it must be last year. Anyway, in any event, it's a sort of annual increase in rates essentially at the firm.
And we said Mr. Brooks's experience rate.
It will be the senior counsel rate for all of these.
Senior counsel rate. Okay. And his level we said is over 15, up to 15 years.
Yes.
Mr. Butler's was also within the normal range. Okay. And the full amount. And your fees, Mr. Anderson, are also included here.
Yes, they are in the disbursements of, I think it's just over 10,000 dirham.
You had to fly out for this, Mr. Anderson.
I'm sorry, Richard?
Have you had to fly out to Dubai?
No, I was here anyway, so I don't have flight costs included in this. Okay. This is just my brief fee.
Okay. I thought you might have really cheap flights then.
They weren't too expensive, but I'm not senior enough to be flying. I'm not senior enough to be flying business, Registrar.
Right. Okay, so we're at 134,000. Mr. Anderson, if we could take this down to 120,000, please.
Yes, of course, Registrar. 120,000. Usual order. So for all of these costs, will the usual order, so both the final detailed assessment and that order you've just made, will the usual 14 days apply?
Yes, 14 days for payment. Okay.
Okay, Registrar. Well, if there's nothing else on that, I think that concludes the Sunset Party's assessment. I'm sort of in your hands. Obviously, we've got our points of dispute in relation to the fixed sentence bill of costs. I can take you through that. So obviously, you may want to hear from Mr. bin Herz first. I'm sort of in your hands as to the best way to go about this.
I would like to hear from Mr. bin Herz first. if you could take us, Mr. Ben Herz, through your bill of costs.
Your Honor, we don't want to go through it. We just rely on the points that we have already raised. So in case he has any concern, maybe then I think because honestly, I have another hearing I have to attend.
Okay, all right. Mr. Anderson, sorry, so your bill of costs, Mr. Ben Herz, just let me have a second look at them.
246,000, which is nothing compared to what they have claimed.
Sorry, they are at, do you have a bundle reference, Mr. Ben Herz?
Just 1 minute, please.
It's 426 of the bundle, Registrar.
426, okay.
Yeah, 426, that's correct.
Try to be as speedy as possible. Mr. Anderson, any points you'd like to raise?
Yes, Registrar, I am conscious of the time. Do you know how much longer we have of the hearing?
We have just shy of half an hour, so about 22 minutes.
Okay. Well, I am to some extent then in your hands. Obviously, you will have seen from our points of dispute that we have done the process of going through item by item, and frankly, it may be that we don't have enough time to do that this afternoon. So it may be that if all the parties and you are agreed, Registrar, I can just take you through the general points that we've made.
General points, yeah.
I think we would be happy with the sort of broad brush discount to the fees claimed on the basis of the general points of assessment, given the time remaining.
Let's look at a 20% reduction.
Well, could I perhaps just take you quickly, it's sort of 5 minutes or so, through the general points we've made? Because in my submission, it will probably be appropriate to make a more substantial discount than just 20%. So our points of dispute are at page 474 onwards.
7 point.
Before we go into that point, please, Your Honor, I just want to state one thing. Okay, Mr. Milon, he has confirmed earlier our cost of bill. In a meeting was held with Noor Hinedi earlier, and that record, you are fully aware, does not exist anymore now. But he did confirm our cost, because when we talked about this cost, clearly she said, okay, that I cannot see it in our portal. Okay, and then she directed this question to Mr. Miller. He said, yes, I know about the cost, which was granted to them, and we have no issue with that. And unfortunately now that record does not exist. And everybody knows what happened with that record.
I'm sorry, I'm not following, Mr. Ben Herz.
No, but that's the fact. That's a matter of fact, you know.
No, I'm not following. I don't know what this refers to. I don't know what you're referring to.
I would see this refer to one of the meeting held between both law firms, okay, which was conducted by Noor Hinedi, who resigned now from the DIFC. When we asked for that record was 50% deleted. And we have the deputy chairman of the DIFC confirming, okay, the only thing we can do, we can ask her to leave, to submit her resignation. But now, because we are coming to our cost, we don't have that proof to show, okay, that was accepted, in fact, earlier by them.
Okay, Mr. Anderson, is there any
I don't want now to argue much in this, what was happened, okay, but I think the entire DIFC knows about it. And I have the email, by the way, from the deputy chairman.
My instructions are that we've got no knowledge of this at all. the previous registrar, as far as we're aware, hasn't made any orders in relation to the costs of the fixed sentence parties. There's been a clear order for you to subject them to detailed assessment, and that is the basis on which we've been proceeding up until today. I'm afraid I don't think I can help you much more because we don't really know what point is being made, I'm afraid.
Well, we will only know if that record is traced, the original one. I think then it will be very clear for the registrar, okay, Ms. Ayesha, to know what happened exactly in that meeting.
Okay.
I'm not sure, Registrar. Are we still then proceeding with?
We're proceeding. Yes, if you could take us through the general points. Yeah.
I'm grateful. So I'll be brief with these points. The responses begin at. Let me take you to the relevant. Unless you have it up already, I'll take you through it in the points of dispute, which begin on 474. So you'll see there's in the first sort of 4 pages we've made a preliminary point in relation to proportionality, and I can sort of summarise that in this way. The applications in relation to which these cost orders were made were straightforward applications. They were sort of pure procedural points. You probably would have seen, Registrar, from my skeleton that they only really concerned 3 things. It was permission to bring a counterclaim, permission to file an additional witness statement, and then directions that the claim be transferred from Part 8 to Part 7. That's what the lion's share of the application concerned, or in fact, that's what the totality of the application concerned. In those circumstances, we say that the total figures claimed of over 250,000 dirham are disproportionate in relation to the simplicity of those applications, and especially when one puts that into the context of the total costs claimed by the sunset parties in relation to a 2-day trial and a committal application, which were sort of 5 times as much as that, or put another way, the costs claimed in relation to this very straightforward procedural application are about 20–25% of what we've claimed for a 2-day complicated trial plus a committal application as well, along those lines, about 20% or so. So that's sort of the first point on proportionality. The second point to note is that actually the appeal itself, in relation to which these costs arise, didn't actually need to involve any consideration of the merits of the dispute. The reason I use the term pure procedural point is because what had happened was that the initial hearing had been vacated. The first instance judge had decided not to allow the other side to put in the additional documents to bring the counterclaim, and the appeal was successful essentially on the basis that the hearing had been vacated, so there was no prejudice in allowing them to put in the counterclaim and the extra documents. So in that sense, it was a straightforward application. It didn't, in other words, require the other side to justify their counterclaim by reference to its merits of success, and we've quoted in our points of dispute the relevant paragraph from, or the relevant 2 paragraphs from the Court of Appeal's judgment. They start at the very bottom of page 475 and into 476. They just summarise this point that this wasn't a case where the parties had to spend a lot of time and preparation looking at the merits of the counterclaim to work out, for example, whether it had a real prospect of success. This was sort of literally a sort of procedural point about the fact that, well, trial has been pushed off anyway, so why not just allow them to be able to file these documents? So in that sense, it was a relatively straightforward application. And that's sort of the sort of first general point on proportionality. I don't know if it would help maybe Registrar to just go through our 4 preliminary points now. I'll go through the other 3, shall I? The second is that we've identified in the bill of costs that there are various entries where there are basically errors. There are errors that we've identified in the should of costs, whether it's adding up errors or whether it's because narrative descriptions are unclear or because there are multiple items of correspondence in a single item, or sorry, multiple bits of correspondence in a single item. Where that takes us in terms of how much time we've got left in this hearing is that my submission would be that normally, to the extent that there would be any doubt, that has to be resolved in favour of the paying party on the standard basis of assessment. And if that isn't manifested by going through it item by item, it ought to be manifested in a sort of additional standalone discount to the total figure. In other words, where we have found errors in the bill of costs, because doubts ought to be resolved in our favour, there should be a discount to reflect the fact that if we were to go through it item by item, there would almost certainly have to be deductions for sort of arithmetical errors on that basis alone. That is in a sense linked to the third preliminary point, which is on page 478, where this is a smaller point, but we've essentially, in addition to that, identified that some work has been incorrectly categorised as well. And again, it's the same point. To the extent that there's doubt, we say that that should be reflected in a discount to the overall figure. The fourth point is a bit more substantive, and it relates to VAT. There are 2 invoices which Mr. Bin Herz might need to sort of explain and take us to, but there are 2 invoices that we've identified there that don't, on the face of the invoices, charge VAT, but VAT has been claimed in respect of them in this bill of costs. So, absent sort of clarification as to what the position is on that, our submission would be that there's going to have to be a discount for the VAT cost claims, because it looks on the face of the invoices that in fact no VAT was chargeable, but yet it's been included in the overall calculation figures. So can
you clarify that, Mr. Bin, before we
the VAT can, Your Honor, the VAT can be reduced. We have no issue with that.
I'm very grateful for that. I think you're on. I think, Registrar, that will obviously be a standalone reduction on the face of the bill of costs. I'll just get you the page number. I hope to assist you with that. But otherwise, while I'm doing that, Registrar, otherwise those are the sort of preliminary and sort of overall points that we had in relation to the appellant's bill of costs. It should be around page 434.
434.
Yeah, so it's the first column, the small column. If you see 1, 2, 3 lines across, 3 columns across, the smallest column next to the narrative is the VAT column. And the grand total of VAT claimed is 13,146 dirham. So I think, if I understand Mr. Bin Herz correctly, I think we're agreed that that comes out of the assessment.
Yeah. Yes.
All right, I'm not following. 434.
Yes. So if you at the grand totals row, just
grand totals. Oh, there. 13,000.
Yes, they don't have the heading, but you have to scroll all the way up to the top of the table. But essentially, those 3 rows in order are VAT, then disbursements, then profit costs.
Okay.
So
we can.
It is the VAT which has to be taken off.
Okay, so we'll remove the 13,000 figure.
Yeah.
Mr. Bin Herz, I'm going to be relying on you for the arithmetics on this one.
Yeah, that is fine. I think we have no issue for taking off the VAT. By the way, just to highlight your register, since you have only a very short time, okay?
I have time, Mr. Benhaz. It's you who doesn't have time.
Okay, no issue. Sorry. To be honest, I have another cassation court also, which I have to attend.
Be as quick as possible. I understand. Yeah.
Okay, anyway, so let us, I think, make this all short. Since we have no issue, we are accepting the VAT to be removed out of the cost we have submitted, or the bill we have submitted. But definitely, I think we wouldn't agree to one issue that he has raised. This, whatever our submission was simple. In fact, the case, it is the same. The argument, it is the same from beginning. So you cannot say whatever we are producing is simple, and whatever they have produced is complex. So if we accept the fact this case is complex, then it shall apply to all. You know, so it seems everything is complex. Even today, hearing is complex, to be honest.
I think, Registrar, my answer to that would be there's a distinction needs to be drawn between a complex case and a simple application. You know, it couldn't be the case that an application for an extension of time, for example, of 14 days to file a witness statement in the context of a huge fraud dispute could be considered a complex application simply because the case was complex. It depends on what the application is seeking, and in this situation, I've taken you to the section of the Court of Appeal's judgment, which sort of explains that this wasn't an application which was looking at the merits of the case or the sort of underlying legal principles. It was simply a sort of procedural question of convenience as to whether or not Part 7 should be used, and then, if so, whether a counterclaim should be allowed to be brought and an extra witness statement filed.
Subject matter remain the same.
The subject matter.
I don't think we can apply different parameters for each hearing. I think the parameters should be same.
Registrar, you have my submission to that. There was just one additional point in relation, given that we're doing this with a broad brush, there was one sort of point in relation to the cost claim, which I think I ought to draw your attention to, which is item 7. Which
I was just about to ask you.
Yes, that strikes us as being a very large disbursement in respect of for external counsel in respect of what was a straightforward application.
Mr. Benhaz, can you shed some light on? I know you're in a rush, but if you could just shed some light on that.
Ashud Kamal is a registrar. Sorry, he is a registrar lawyer who's based in the UK. Okay, and we acquired his services. So he is a senior lawyer who and the leading lawyer, to be honest, in the entire case. Okay, so whatever they apply for their senior lawyer, let me at least, I think, give him the credit, the same rate should apply to him.
Mr. Anderson, would you like to respond before I make my finding?
Yes, very brief, Richard. I think I'm just trying to find the reference in our points of dispute on this, because I think the point we've made is that it seems to have been a very, even if you were to take, you know, senior counsel hourly rates as the guideline for external counsel, it seems to have been a very, very large amount of hours spent in any event. I seem to remember the figure being something like 30 hours to read into the case or something.
30 hours, yes.
30 just 30 to read
hours, and there seems to be an overcharge on the amount of hours.
30 hours is reasonable.
It's a very straightforward appeal, though, Mr. Benhaz.
I can tell you, Registrar, it hasn't taken me 30 hours to read in for the purpose of this hearing. I dare say I probably did similar amount.
Well, you did need to do the advocacy on the appeal and face the Court of Appeal, Mr. Benhaz.
That's true, Registrar. I don't suppose you're quite as intimidating as the Court of Appeal, but no, certainly, obviously. I
assure you I'm not.
Certainly, it's not the case that you can sort of compare my fees for today with those fees. Yeah, we wouldn't suggest that.
Can you look at page 450, please?
450.
Please. It shows the hourly rate is 2,400, whereby in their claim, they have a claim 10,000 per hour.
We've reduced that.
So that is very reasonable. So
We've
then they should
reduced
apply
that.
2,400 for them as well.
First of all, we've reduced Mr. Al-Tamimi's hourly rate to keep it in line with our indicative hourly charges, but we're not looking at your rates right now. But in item 7, we're looking at council and whether or not it should have taken 30 hours to review that point on appeal.
He need to prepare the skeleton argument during those hearings. He attended the hearing, so I think it is very reasonable.
Okay. Mr. bin Herz, I will take council's hours down to 20 hours, which I think is reasonable.
It is not fair, Your Honor.
We are looking, you cannot compare your costs to their costs.
You know, it will not 100%, it takes more than 20 hours. Okay, if you want to resolve, fine, we would accept a reduction of 5 hours. Okay, at least we need to be fair for both parties.
Mr. bin Herz, I fear that what is happening right now is you're comparing your cost order with the cost order that the sunset parties have gotten. It's a fairly straightforward appeal.
Why not?
Can I just
comparing two different things. Yes, Mr. Anderson.
I'm so sorry to interrupt you, Registrar. I just want to, can I clarify whether that 20 hours, is that overall or is that a reduction in the reading case number from 30 to 20?
No, that's overall.
Yes, that's what I understood. Thank you.
Yeah, that's overall, I swear. Because okay, moving on from that.
Yes, I don't think I'll just quickly double check, but I don't think there were any other sort of large items in a similar category to that. The rest of our points and the points of dispute were essentially, as I say, going through the sort of schedule item by item, and you have my submission on that in the time available, a broad brush approach would be fine, but it ought to be, in my submission, a relatively significant discount, given the simplicity of the appeal.
Well, what about before I come to that point, what about your costs for the assessment proceedings, Mr. bin Herz? I don't have a statement from you. Sorry?
If you don't mind, allow us time for 10 days to submit our cost of assessment.
Do you not have your costs for preparing for this hearing?
No, to be honest.
Would you prefer to do written submissions for a summary assessment rather than an order to be assessed?
Unless you would put it in this equal to whatever their cost of assessment, then I think we have to do that. So.
But their bill was much larger than yours.
No, but we raised also the point of dispute. So will be incorporated, no?
Registrar, if I was just taking some instruction, could I perhaps offer something? I don't think it's not going to be possible to do a summary assessment of Mr. bin Herz's costs today, but we're also keen not to have to trouble you again with another detailed assessment of those costs. So rather than making an order that those costs be assessed, if not agreed, would you perhaps be open to, if the parties can't agree them, some short written submissions and then summarily assessing them on the papers?
So Mr. bin Herz has asked for 10 days to prepare those.
I'll take some. That's fine from our perspective. We would hope that we'd be able to sort of agree them, but if not, I think we would just ask the court to summarily assess them on the papers.
Okay, then that's fine. Okay. And then going back to the reduction point.
Sorry, we couldn't understand because there is a fire alarm in our building. Maybe you can hear it.
So going back to we can hear it.
So that's mean we
it doesn't
might
bother
have to
me.
keep
So
in the building.
Just to wrap up, so going back to the broad brush deduction, We'll go back to a 30% reduction, Mr. bin Herz, in your costs. In addition to the removal of VAT and the reduction of overall council's costs, 20 hours. So I'll rely on you for the arithmetics. Mr. bin
You are
Herz,
reducing 13% in cost. You're moving the VAT and additional 10%. Sorry.
the council's hours. Yeah.
In the building.
Is that fair?
Leave the building immediately.
You can appeal it, Mr. bin Herz. You can appeal my decision.
That's fair, you know.
You have
We need to be
the
treated
right to
equal,
appeal.
you know.
You have the right to appeal.
Yeah, but I think here we are attending today and we need to be treated equal.
You have the right to appeal, Mr. bin Herz.
Very good.
Unless there's anything else, then I will wait for draft orders to be submitted by the parties. Yeah.
Nothing further from me, Registrar, other than to thank you for your time.
Thank you very much, gentlemen. Thank you.
Grateful.